First, we're going to give a basic overview of the H-1B visa process. I'm sure most of you are familiar with the process, but we will touch upon it. We're then going to go into the H-1B cap numbers and what our predictions are going to be as far as how long we think the cap numbers will last this year. Then we're going to touch upon H-1B cap exempt organizations and strategies. This is always kind of an interesting area because a lot of companies and employees don't know that certain organizations are exempt from the H-1B cap. Then we're going to touch upon the F1 cap gap rule for students. That's a question we get frequently from people who are on F1 status and have OPTs that expire prior to October 1st. Then we're going to discuss the Neufeld memo. Yeah. And the heartache it has caused employers in the IT and staffing industries over the last few years. The end client letter is always a big topic with staffing companies. We're going to touch on that as well as changes in work locations, which again, staffing companies do encounter, and what staffing companies have to do once an employee changes their work location. And of course, lastly, visa processing and 221Gs at various consulates around the world. That's also a hot button issue right now. And as Amy had mentioned before, you'll have an opportunity to ask questions at the end of the webinar. So we'll start with just a basic overview of the H-1B visa process and who qualifies for it. Don't want to bore you too much with this because we assume the fact that you're signing into this webinar probably means you already know a little bit about the H-1B visa. Yeah.
Sorry to interrupt. Mm-hmm. It looks like we're having technical difficulties on my mic, so if I'm in the background, I do apologize, you
all. Okay, so what is the H-1B visa? The H-1B visa basically applies to companies who want to hire individuals in specialty occupations, basically meaning a professional job, where the duties are highly specialized and the employee actually has a specific degree in a specific field that's related to the position that the company wants to hire that individual for. So that right there is the basics of the H-1B process. I'll give you an example. Let's say an engineering company wants to hire an engineer and the person they want to hire has a degree in engineering. That's a typical type of H-1B visa application. And basically the job itself has to require that someone have a degree. So it is a professional position, and it doesn't apply to every job that's out there in the country. So next we're going to address the H-1B cap numbers, and I'm sure all of you are probably familiar with this as well. Right now the regular cap is set at 65,000. Of course, this is they do have 1,400 for nationals of Chile and 5,400 H-1Bs for nationals of Singapore. Those are actually subtracted out of the 65,000 regular cap. So you're really looking at about 58,000 or so regular cap numbers. What they say is if the cap gets hit, then if those numbers for Chile and Singapore are not used, they basically add those back in come October 1st. But we've never really seen that happen, so we don't know where those numbers disappear to. The U.S. also has a 20,000 U.S. advanced degree cap. So let's say that you've graduated from a U.S. university and you've got a master's degree or a PhD, and the regular 65,000 H-1B cap has expired, but the 20,000 has not, then you're still eligible to receive an H-1B visa because you're placed in a completely different cap than people who graduate with just, let's say, a bachelor's degree or something. Now, new H-1Bs can be filed on April 1st, and that would be for an October 1st start date. A new H-1B is basically a company that wants to file an H-1B visa for somebody for the first time. It does not apply to H-1B transfers, extensions, or people who have been previously counted against the cap. Now, what does that mean, previously counted against the cap? Let's say that a company has filed an H-1B visa for me. A previous employer has filed an H-1B visa for me, let's say 3 years ago, and it was approved. Then in that case, let's say I joined the employer for a few months or didn't join the employer or what have you, and I switched to some other status, and many years later, a company wants to file an H-1B for me. Well, in that particular situation, I'm actually not subject to the H-1B cap since I've already been counted against the cap once before. And that's key for people to keep in mind when they've actually had a previously approved H-1B. Because we've done a lot of cases where, a person doesn't hold H-1B status, employer comes to us and says, listen, we want to do an H-1B for this person. They're in some other status. Do we have to wait until April 1st and October 1st in order for them to actually start working? And, the first question we ask is, have they ever previously held H-1B status before? And that makes a big difference. Now, as far as when we think the H-1B numbers will run out, as you can see here in fiscal year 2012, companies started filing April 1st, and it didn't run out until November. And that's probably in large part due to the economy and or due to the Neufeld memo, which we're going to address here fairly shortly. Now, in last year's fiscal year 2013 cap, companies started filing in April, and just a few months later, it ran out in June, which was much faster. So what's that an indication of? Well, maybe the economy's gotten better in some areas in some industries, and maybe companies as well as attorneys have adapted to the changes brought about by the Neufeld memo. What's going to happen under this year's fiscal year 2014 cap? Very, very difficult to say. Our guess is it's probably going to be somewhat similar to last year. So companies and employees should kind of keep in mind that it's going faster and faster over the last few years. Go ahead and get your cases in on April 1st itself, and prepare. Keep kind of think about the H-1B cap running out again. May, June, July, in that time frame. That's our best guess. Now, I touched upon the H-1B cap exempt organizations before, and this is really important for employers and employees to know. These institutions of higher learning or related or affiliate nonprofit entities, nonprofit research organizations, and government research organizations are all exempt from the H-1B cap. What does that mean? Basically means they can file an H-1B for anybody at any time and are not limited to either the cap numbers, the April 1st filing for new H-1Bs, or the October 1st start date for new H-1Bs. So what you'll see is a lot of universities benefit from this. They don't have to worry about the H-1B cap or start dates. They can basically file an H-1B for anybody at any time who qualifies for it and have the start date at any date that they want it to start. Now, there's a little wrinkle in here that a lot of folks don't know about as well, which is the regs say, someone working at these three types of entities or organizations. And I'll give you an example how some employers can benefit from, even though they're a private employer, some employers can benefit from that language. Let's say as a private employer, I've got a contract with a university, for example, for the rendering of services, whatever that is. It could be research, it could be a number of other things. And I want to hire a worker who's actually going to be working at that university, in the sense that the worker will be employed with me as a private employer as a W-2 employee, but they're going to be conducting research, for example, at the university location itself, pursuant to a contract that I have as an entity with them. In that situation, even though I'm a private employer who otherwise would have been subject to the H-1B cap, since the employee will be at an institution of higher education, and that would also apply to government research organizations if you're actually physically located at those organizations, then me, the private employer, can actually file an H-1B visa for that employee without having to worry about the H-1B visa cap. We've seen those situations a number of times, so employers should keep that in mind if you actually have that type of arrangement with a university or college or any of these other organizations. We've also seen situations where, you know, private schools that have that otherwise would be subject to the H-1B cap actually have formal affiliations with universities and are, as a result, cap exempt. And so, you know, the question gets asked, really, what is related or affiliated really mean? And what the Immigration Service looks at is, do you have a formal affiliation with that entity? It's not just kind of doing business here and there. There has to be something more formal, more regular that the organization has with that institute of higher education or nonprofit research organizations or the government research organizations. The F1 cap gap for students. This is a really, really key issue that comes up quite frequently, and we want to clear up a couple of things here first. One is the F1 cap gap also applies to certain J1 exchange visitors as well. Sometimes people don't know that, but it doesn't apply to every J1 category. You know, so if you're a J1 au pair or something, it doesn't really apply to that. So you want to look into that if you're a J1 and speak to your immigration attorney. But what it means is, if you timely file an H-1B change of status application, you can remain in the U.S. until October 1st, which is the start date on the H-1B petition, even if your F1 or J1 status expires prior to October 1st. And there are two situations that this typically comes up, and I'm actually going to hit on the second one I have below first, which is, let's say I'm on F1 status and my OPT, which is optional practical training, expires, for example, June 1st. My employer files an H-1B on April 1st, and let's say April 15th or April 20th, the USCIS receipts that H-1B in. The employer gets an H-1B visa application, not visa application, H-1B receipt notice, and if that happens, then in that case, that H-1B is pending with the USCIS, and my OPT is automatically extended until October 1st. So that covers me from an employment standpoint from the date my OPT expires until the start date on the new H-1, and therefore there will be no interruption in employment. And that's important for a lot of people who are on F1 OPT. If the H-1B petition gets denied, then that benefit ceases to exist at the time of denial. Now, another scenario. Let's say that you filed the change of status during the grace period. You know, every F1 has a 60-day grace period after the expiration of their status, and every J1 has a 30-day grace period. Excuse me. So let's say that's filed during the grace period. Well, in that case, you're allowed to stay until October 1st, but you're not allowed to work until October 1st. So if your OPT is expired and you've got 60 days to stay in the US and you filed for a change of status to H-1B, you can stay until October 1st, but not work until October 1st. And that's a key distinction that you need to keep in mind. Now, the Neufeld memo, which came out around January 2010, and what the Immigration Service did at that point was issue a memo clarifying what constitutes a valid employer-employee relationship to qualify for an H-1B specialty occupation. Now, that memo had a significant impact on a number of companies or industries. One is companies where they have H-1B employees working at third-party and client work sites. And this typically applied to IT consulting or other staffing industries. It also had a significant impact on owner employees of companies. Prior to January 2010, if you actually were an owner of a business, and let's say the business was, doing business, had employees, but you happen to be a part owner and you were on, F1 OPT status, that company could actually sponsor you for an H-1B visa. But because of the redefinition of the employer-employee relationship, this became extremely difficult for owners of companies who are also employees of the same company. At first, the Immigration Service said you couldn't do an H-1B for that person, but then that changed, and what they're saying now is, as long as you have an independent board of directors, even if you're an owner of the business, and that independent board can fire you or has the ability to fire you from the business, then you actually can do an H-1B for that employee. Of course, that means a lot of paperwork, corporate attorneys, and the whole gambit. Now, as far as IT staffing and consulting companies, the biggest impact it had outside of trying to prove right to control that employee, because the employee is offsite and you have to provide documentation showing that the company supervises the employee, has benefits for the employee, maybe what's the tax treatment for the employee, and all the things that companies would generally have for a W-2 employee. The biggest impact the Neufeld memo had was requesting an end client letter. So for IT staffing companies or other staffing companies that place individuals at third-party client sites, a lot of times you have many layers between the employer and the end client. It could be one, two, or it could be a direct relationship as well. So what the Immigration Service has been requiring is a clear path from the employer to the end client. So you've got to show the vendor agreements, the purchase orders, and a letter from the end client show, basically, setting forth what's the project, what's the term of engagement, what are the duties, the requirements, and who actually has the right to control what the employee does. The biggest problem here is because it was such a sudden change in 2010, a lot of these end client companies did not know that this was a new USCIS requirement, and a lot of them just didn't want to give these end client letters. And frankly speaking, we do a lot of these cases, and although it's gotten better over the last number of years because a lot of these companies have realized that this now is a requirement for H-1B processing or for immigration processing. They've gotten better about giving the end client letters, but sometimes they just don't want to because their legal departments might say, you know what, we don't want anything in writing on stuff like this because why should we? That's really not our employee. That's really the employee of, the individual or the company that actually sponsored them for the H-1B visa status. So that begs the question, are there alternatives to the end client letter? And oftentimes you'll hear attorneys saying no, and I kind of put this in as a joke, but what it really should be is just kidding, kind of. Now, what are the alternatives? And, I do want to start off by saying there really is no perfect solution or alternative to the end client letter. Cases where the company does have the end client letter from the end client, most of those H-1Bs, barring bad decisions, do go through fine. If you cannot get an end client letter, here are some of the things that we've seen. And some of the topics I'm going to address here really don't apply, to new H-1B cases. Sometimes they could apply to situations where somebody is already on H-1B status and working at the end client and you're doing an extension, but you can't get an end client letter. It could apply to also a new H-1B where let's say that an employee is on F1 status on OPT and they're placed at the end client and the employer wants to file an H-1B for them. But still, even though they're placed at the end client does not want to give an end client letter. What have we used before? We've used copies of badges that have the name of the employee on it as well as the company, and name and information on it as well. We've used emails, from the clients confirming the company policy is not to issue end clients. For example, employees have emailed their end client officials and asked, well, we need an end client letter for my case. And if the company says no, at least you have that documented in an email. We've also used, for example, affidavits. That's worked sometimes. Obviously, badges and emails are the best, but sometimes an affidavit from the employee or from the employer stating that they are actually placed at that end client site, what their duties are, what the project term is, etc. That will sometimes work. Um, so that might be something that you want to keep in mind as well. Now, if it's a direct client situation, let's say you have employer and then end client and nobody in between, we have seen situations where just the agreement between the parties and a purchase order PO work as well without an end client letter. Now, having said all of this, employers and employees should keep in mind that these are some of the alternatives that have worked in our experience before, but a lot of this is also USCIS officer specific, and we've seen inconsistencies in how these types of cases are adjudicated, and that's something that employers and employees have to keep in mind as well. Another big area as it applies to staffing companies is changes in work location and H-1B amendments. Now, again, I'm a little off topic because some of this sometimes does not apply to brand new H1s. They apply to H1s that are already in existence for an employee. But the fallacy has been that, let's say I'm an employer, I file an H1B visa application for an employee. It's approved for a location in New York, New York. That's what's on the LCA, the labor condition application. Employee starts working at that work location. And then you need to transfer that employee to a different end client site in Los Angeles, California. File a new LCA for that work location. Employer meets the prevailing wage requirements and everything else, so you think everything is fine. That's actually not the case. It's fine with the Department of Labor, because you filed a new LCA attesting to the fact that you're complying with the wage requirements and everything else, but it's not fine with the Immigration Service, and they're two completely different, governmental entities. So what the Immigration Service requires, that if you file a new LCA for a new location after a case is approved, and the employee moves from that location to a new location, because a new LCA is required, you're supposed to file an H-1B amendment and update that with the Immigration Service. Is this a cumbersome requirement? Yes. Is it a legal requirement? Yes. And a lot of employers do not know that, and they should. And the reason they should is because there have been many situations where, U.S. site visits have been conducted over the last, couple of years. And site visits are where, immigration officers will go out to the work location as listed on the H-1B application to verify that the employees there and all the terms of the I-129 petition exist. And what they're trying to do, obviously, is just root out fraud. So the work location that they actually go to is the work location listed not on the LCA, but actually on the I-129 petition itself. So if I file an I-129 petition, which is an H-1B application, with an LCA, and both of them have New York, New York as the work location, but then the employee shifts to Los Angeles, California, and the company files a new LCA, that work location on the I-129 doesn't change unless an H-1B amendment is filed. And so where's that officer going to go if no amendment was filed? They're going to go to New York, New York. They're going to see that the employee is not there, and it's going to cause problems. And I have seen situations where that's happened, and what they usually do is email the employer, the employer's attorney, and you can get that straightened out. But there have been cases where, because an amendment was not filed, the USCIS has actually sent notices of intent to revoke the approved H-1B petition. And, when you get to that stage, obviously it's serious business. So work location changes, if you need a new LCA, file an H-1B amendment. Or another alternative is, if you think that an employee could be either in New York, New York, or LA, California, maybe you want to go ahead and get a LCA certified for that work location prior to even filing the case. So basically, get an LCA filed for certified for both locations. And if you already have an LCA certified for that location prior to filing the H-1B case, then an amendment is not needed. It gets a little complex. We have a link here to a blog piece we wrote on it, so I, do encourage you to take a look at that. Our blog is actually on our website, which is bashyamspiro.com, and that blog that we wrote on H-1B amendments is on there, called "The Times They Are Changing." We always try to get a little funny and cute with our blog posts, so it keeps people interested. So just take a look at it when you get a chance, and of course, feel free to send me an email and ask me any questions. And at the end of the presentation, I will provide you with my email address. The last but extremely important topic I want to address when it comes to H-1B visa processing is consular processing of H-1B visas, and the often, the evil 221G is what we want to call it. So what happens when you change your status from F1 to H-1B? Your case is approved, your status changes from F1 to H-1B on October 1st, for example, and then in, let's say, February of next year, you need to travel outside the US, and you don't have an H-1B visa stamp. Well, in that situation, you actually have to go to a US consulate in your home country, or a third country if you're, in certain situations, and apply for an H-1B visa stamp. Now, that process, many years ago used to be fairly routine, except in the last 3 or 4 years, it's gotten very complicated for IT professionals, especially in India. So for IT professionals who are actually going to go to India to do H-1B visa processing, we've seen a lot of situations where they are reluctant to travel because they've heard all of these horror stories about visas getting denied, or 221Gs being issued and them being stuck for quite some time, even though their cases are completely legitimate and all the documentation has been submitted to the consulate. That has been more frequent in recent years. Now, what is a 221G? That's where the consular officer looks at all the evidence and decides, well, they want more, and sometimes we've also seen them look at all the evidence be there, and then request everything that they've already looked at before, which is quite inefficient, and we don't understand why that happens, but it does happen. But 221Gs right now can take quite a bit of time. So let's say I apply for an H-1B visa in Mumbai, for the sake of discussion, and I present them with everything, copy of my H-1B petition, the end client letter, everything. They issue a 221G saying they want, let's say, an employee roster list for the company or company financials. Whether or not you've submitted that to them before or not, you need to do it again pursuant to that 221G. Once it's done, the million-dollar question is, how long are they going to take to make a decision to approve my H-1B visa? Because you need to get back to the US, start working again. Most employers don't want to wait that long. But we've seen 221Gs taking anywhere from 2 to 3 weeks to 3 to 5, 6 months. And there's really no rhyme or reason to it. And it's really hard to determine exactly when those 221Gs are going to show up. Again, mostly they're related to IT and staffing professionals, especially IT professionals. Every once in a while, we do see those pop up in regular non-staffing related H-1B cases, but that's a lot more infrequent than in the staffing context. So if you're an IT professional traveling outside the United States to get an H-1B visa, or especially traveling to India, you do need to speak with your immigration attorney first. And you probably also actually have to speak with your employer and, basically say, listen, this is a possibility. If I get a 221G, even though all the documentation is submitted and should be a fairly clear-cut case, it may take anywhere from a couple of weeks to a couple of months, and they need to be aware of that, because you don't want that surprise for an employer. That way, they know what's a possibility, why it might happen, and maybe you can work from outside the United States if you got a 221G until the case is ultimately approved. Couple of other things real quick before we go to questions. Another question we get often for these new H-1Bs is it worth doing premium processing? So here's our response to that. And it just really depends. So let's say that you're an employer, you want to file a new H-1 for an employee, and you file it on April 1st. Right now, current processing times for new H-1s are anywhere from 3 to 5 months. And honestly, I think it's going to be more towards the 5 month side, especially as all these new H1s start, to be filed beginning on April 1st. You could say, all right, fine, I'm willing to wait 5 months, no problem, because you can't really, that H1B doesn't kick in if approved until October 1st anyway. And that's a completely legitimate way of looking at it. The other way of looking at it as well is, we want some, because it's taking 5 months, which is a very long time. What happens if the case is denied at that point? I won't have the services of this F1 OPT student or, anybody new you're going to have working for you starting October 1st. And in that case, you may want to do premium processing. The premium processing fee is an extra $1,225 to the Immigration Service. What does that buy you? It buys you a decision within 15 days of filing. And what does a decision mean? It means either the Immigration Service approves the case or they issue a request for evidence within that 15-day period, which you then have to respond to. And once you respond, then they have 30 days to give you a response to that. So it does, extend it out a little bit. We have seen employees question whether it's worth doing the premium processing because they've heard on a forum or somewhere that the immigration adjudicators working for the premium processing divisions are actually harder than the regular immigration adjudicators. And I don't really see it that way. From an experience standpoint, I think a case is strong, or weak or mediocre, regardless of whether you do premium processing or non-premium processing. If you've got a strong case and you want to get a quick decision, do premium processing. People who have to make, for example, life decisions on, renting apartments, buying houses, moving from one location to another, who have H-1B applications that are about to be filed. You may want to discuss it with your employer because obviously having an H-1B approval in hand at least gives some peace of mind to making those life decisions that are so important for you. So that's that's kind of the debate on premium processing versus premium processing. So that's something everyone can think about on that front. Also, for IT staffing companies, for new H1s, and we've seen this last year and the year before be an issue as well. Because you're filing, let's say that you're an IT staffing company, you're filing an H-1B for a new employee, and that employee is going to be placed again in New York, on October 1st. And let's say that individual, well, let's just keep it at that. They're working in New York. They're going to be placed in New York on October 1st. That's the H-1B work location that you file on April 1st with the H-1B petition. Because April 1st is so far away from October 1st, things can change. So let's say that come, the petition is approved, but come August, that work location no longer exists. The company doesn't have that relationship with that end client anymore. And now that work location is going to be LA, California. Are you going to send that employee, let's say that employee is in China right now. Are you going to send that employee to a U.S. consulate in China with that H-1B approval, a new LCA for the LA location, but the New York location was actually what was listed in the LCA and the I-129 petition that was filed with the H-1B case? Not recommended, because we've seen consular officers at that point just say you should have gotten the case amended, because the terms have changed. Is that a real hassle for employers, as we discussed before, with regard to H-1B amendments? Absolutely. Does it have to be done? Yes. Does that increase the chances dramatically of the H-1B visa processing at a consulate going through if the amendment is there and they see that these are the steps that the employer has taken in order to make sure that everything is right for that employee? Absolutely. So that's something that employers should keep in mind as well. So now I will entertain a few questions here while we have a few minutes. Let's see. Yeah, the voice of the lady in the background is very faint. Yeah, Amy had some technical difficulties, which is why um, you don't hear her talking too much. We have a question here that says, "Hi, have a question. How many months gap can we be between the LCA filing and the H-1B amendment?" Well, that's a great question. Here's how things typically work. Because in the IT industry, there's things are moving very, very fast in these staffing types of situations, and it's hard to actually have leadway from what we've seen from a company standpoint to say, listen, we think this person's actually going to be changing from New York to LA in 1 week. Can you go ahead and get the LCA in and go ahead and file the H-1B amendment beforehand? Legally speaking, that's what needs to be done before the person actually even moves to the new work location. Practically speaking, that doesn't happen. So what I'd say is there isn't a legal gap in the sense that you're not allowed to have 2 months or 3 months in order to file the H-1B amendment. What I'd say is do it as soon as possible. Definitely the LCA, get the LCA done before the person moves, um, and then do the H-1B amendment as fast as you can thereafter. Is the best answer I could give on that one. Okay, we have another question. What if the employee is traveling in and out of the country during a USCIS site visit? Well, that just needs to be explained. So if the USCIS officer goes to a site and that's the site that's listed on the H-1B petition, and that actually is that site is not changed with regard to the USCIS petition or anything else. That's where the employee actually is, but they are traveling in and out of the country. Well, when the officer goes to that location, they were more likely than not speak to whoever the on-site manager is of the project that employee is working on, and that individual just needs to explain that listen, that person actually is placed here. That person is actually doing what is stated, you know, in the end client letter or what have you. But they just happen to be traveling in and out of the country. That in and of itself, the traveling in and out of the country doesn't make any difference for site visits. All the officer wants to know is that what's in the petition is accurate. Next question, which is, if I currently have an H-1B visa and want to change employers, change jobs, what do I need to do and how long will the process take? Well, that question, let's say, yeah, you're on an H-1B visa for an employer, you're maintaining valid status for that employer, and I point that out with emphasis because that's a part of the transfer case. To do an H-1B transfer, you need to have a new employer actually file an H-1B petition for you. That petition would not be subject to the H-1B cap since you've already been counted towards the cap before. And you have two options as to when to join that new employer once they file the case for you. By law, you can actually join that new employer once the case is received by the Immigration Service, or you can wait until the case is actually approved by the Immigration Service. The latter is probably preferred simply because there's more certainty there. And if you change after the case is filed and pending, what happens if it's ultimately denied? Then you'd be out of status. And as far as how long it takes, as I said, regular immigration processing for H-1Bs right now is between 3 and 5 months. You could always do premium processing if you need to change faster to the new employer and want to have an approval in hand before you do so. We do have a lot of questions here, so I'm going to try to address as many as we can. Right now, I'm on an H-4 visa and I'm looking for filing an H-1B visa. I would like to know what are the possible ways to file an H-1B. Well, H-1B simply comes down to employment. Do you have an employer who's willing to extend you a job offer, a legitimate job offer, and a professional job that require someone to have a specific, educational background, meaning a bachelor's degree or higher? And are they willing to hire you for that job, whenever your H-1B is approved? That's basically it. If you're on an H-4 looking to file an H-1B visa, you need to find an employer who's willing to hire you and go through that H-1B sponsor process. Okay, let's see. We are working with a direct client, and they can provide us a vendor agreement, and we already have consultants working for this client, but it's not possible to get a PO with a specific candidate starting 8 months from now, October. Please advise if a PO is mandatory because it's not feasible to get a PO 8 months in advance with consultant's name on it. Different strategies here. One is you could, um, in the H-1B petition, provide the vendor agreement, provide affidavits, from the employer stating that that's where the individual will be placed. Come October, you can provide documentation showing that you already have consultants, placed at that location, and that may work. We've seen that work sometimes, and other times it doesn't. It's really USCIS officer specific. Another thing you could do is if you're 100% certain that that's where your employee is going to be placed, but you can't get the PO with a specific candidate name, many months in advance, you could just try to file the H-1B regular processing. Like I said, you're probably not going to have it even looked at for 4 or 5 months, and that's going to put you closer to that October 1st start date. You're likely going to receive a request for evidence, on that particular issue, and maybe you'll have the PO with the employee's name at that point in time and can submit it and get the case approved. So there are various different things you can do. It just really depends on what you think is the best, what you or your immigration attorney thinks is the best strategy for your case. Next question is regarding supporting documents. Could you please detail on the documents mandatory for filing? That's a very, very broad question. And that's hard to answer because the documentation that's going to be submitted with an H-1B filing really depends on various things. The employer, how long they've been in business, the employer's industry, what is the individual going to be working at a third party site, or are they going to be working at the employer's office site? What status is the proposed employee in? There's so many variables that determine or go into what kind of documentation we or other immigration law firms will submit with an H-1B case. What I would do is, here is my email address. Just send me an email with that question, but give me more details, and I'll be able to provide you with a response. Let's see here. This is a good question. This has been asked many times before. Can you file a new H-1B application prior to April to get it in the queue for consideration when the window opens, or is it just April 1st and they do not accept them prior to April 1st? The fiscal year for H-1B filing is actually October 1st to October 1st. So because the new H-1Bs are going to be under fiscal year 2014, it'll be October of this year until October of next year. So why are you able to file on April 1st? Because you're able to file a new H-1 up to 6 months prior to the start date. And if the start date is October 1st, then April 1st is the earliest you can file the case, and you can't file it any earlier than that. So you really got to time it right to get everything done and ready to go so you can file it so it's received by the Immigration Service on April 1st. And given this year, of course, I'm I'm making an educated guess here, but my educated guess is I don't think all the H-1B visa numbers are going to run out on one day like they used to 4, 5, 6 years ago. But go ahead and make sure you get it in on April 1st. If you send it before April 1st, they'll send it back, many weeks after April 1st, and you're going to be out of luck. Okay, next question. Another good one. Is there a chance that an H-1B amendment can get rejected? Um, there's always a chance that any immigration case can get rejected. That's the fact of the matter. And people have asked that question before with fear that an amendment will get rejected. However, in our experience, we haven't seen that happen yet. So I think the Immigration Service is a little more lenient on these H-1B amendments because I think they know the employer is trying to do the right thing. Number one. Number two, the employer needs to do the right thing, because if an H-1B amendment is not done, you could end up in the situation, you know, uh, that I described before, where there's a site visit done and then the person goes to the wrong location and the employee is not there and they end up doing a notice of intent to revoke, and you don't want to get into that situation either. So employers should do an H-1B amendment. Next question here. Let's see. If the employee holds an engineering degree, is that enough, or does it have to be very specific? Does it have to be a very specific engineering subject matter for the job? For example, a company offers a position that requires knowledge of broad engineering principles, and the employee has specific electronic engineering qualification, but has 4 years of experience working with broad engineering. By law, the degree does have to be specifically related to the field. Um, But in the engineering field, for example, let's say that you're going to hire somebody as an electrical engineer, but they have a degree in communications engineering. What you really need to look at in that situation is, would the would the duties of would the person get the skills necessary in a communications engineering degree, that they would need to perform the duties of an electrical engineer? You've got to really do that analysis. Now, the fact that a person has an engineering degree is good, for an engineering field, but you've really got to do the analysis of duties of the position versus what kind of coursework do they take in their degree program, what do they learn, is all of that relevant to performing the duties of the job? So just want to say it's a great question. In the sense, by law, you do have to have a specific degree, but what's specific or what's not, your immigration attorney really just needs to analyze that, as I said, between the courses taken by the employee versus the duties that they will be performing for you. Okay, let's see. Came to the U.S. on H-4 in 2009, started pursuing masters in 2011, but later got divorced in 2012. I'm graduating in May 2013. Now my question is, can I travel outside of the country on OPT with no F1 visa stamping and a job in hand? So I assume you're at F1, you have OPT, no job, no visa stamping. I would not recommend traveling outside the United States at that point. Also, do keep in mind that, this is kind of unrelated to the topic at hand here, but people on OPT are only allowed 90 days of unemployment before they fall out of status. If you're a STEM OPT, which is science, technology, engineering, mathematics graduate, then you're allowed 120 days of unemployment before you fall out of status. Next question. I'm on an F1 visa and I got a job offer, and my graduation is on May 2013. So I'm not sure when I can ask my company to file an H-1B. So it'd be great if you could throw some light on this because most of the people in my university are having this thought in mind. Yeah, that's a great question. I would say this. What are you graduating in? You know, number one. Number two, is this a master's degree? Are you doing a PhD? Do you already have a bachelor's degree? Because here's the rule. To do an H-1B, the employer, like I mentioned, as I mentioned before, has to have a professional job with specialized duties, and the job requires that someone have a bachelor's degree or the equivalent of one, which is 12 years of experience in a professional field. Um, if you're on an F1 visa and you're graduating with your bachelor's degree in May of 2013, as long as all the requirements for the degree were met, you could probably give that a shot on the H1. If not, then you actually have to have the degree in order to apply. That's not the case. Let's say that you're graduating with a master's degree now, and you've already done your bachelor's degree before, whether it's in the US or outside the US. Then, if that bachelor's degree is related to the job that your proposed employer is going to have, then you can go ahead and have that employer apply for you on April 1st itself because the requirement is that you have at least a bachelor's degree that's related to the job that they're going to be sponsoring you for. So it really depends on your circumstances. And as I'd mentioned to someone before, feel free to send me an email with more specifics, and I would be happy to answer that for you. I'm on an F2 visa. Can I do volunteering in an IT organization for experience sake? Um, yes, you can, and keep the OP. I'm sorry, I misread that. I'm on an F2 visa. Can I do F2? Sorry, you have to be very, very careful about what is and is not considered employment. And on an F2, you're not allowed to be employed. So if if it's true volunteering, maybe, but what I've seen is a lot of situations like this are not true volunteering, especially if it's in a professional organization like that. Um, Again, I would be very careful about that. You probably want to speak to an immigration attorney about it, and you could feel free to give me a call, and we can go into more details. So I can give you a better answer than what I can do here in this webinar. Let's see. I'm just scrolling through the questions here. If you're not a staffing agency, and I do apologize for focusing a little bit more on the staffing agencies. That's only because those are the companies that are having a few more issues with all these new H-1B rules. Um, but if you're not a staffing agency, but a private practice that does sometimes place your W-2 employees working fairly independently but still under our supervision in school systems to provide speech and language therapy on behalf of schools' permanent employees on leave of absence or perhaps to fill a vacancy left by a school employee, then do we have to request the school systems provide an end client letter? Um, it really depends. It depends on, for example, if these employees are actually going to be working out of your employment, your employer's office, for example, but they're required to make short trips for various reasons, for these types of reasons, then yeah, you don't really typically need an end client letter or an H-1B amendment. But if they're going to be spending significant amounts of time off site like that, to where if you accumulate that amount of time over the course of a year, it's significant in a sense it's over 90 days or what have you, then the way the H-1B it has to be prepared and filed and what you have to do subsequent to filing would need to change. So what I do is, because I provided a fairly broad answer to that question because I don't have all the facts I need to provide a really concrete response, please do send me an email and we can set up a time to talk, and I'll be able to help you out a lot more on that one. Is there a pattern on site visits from USCIS? They said no. So it's all random according to the USCIS, and we have not really seen a pattern on that. So here's a question that's being addressed to an immigration law firm. Does the employer need an attorney to fill out the paperwork related to the H-1B visa, or can it be done by the employer, him or herself? There are certain types of immigration cases where we've seen people do it on their own, and sometimes be just fine. We've even seen employers sometimes do H-1B, applications on their own. But in this particular context, more employers get it wrong than get it right, simply because there are a lot of rules to follow, and a lot of employers don't know exactly what they all are. And H-1B, processing has become more complex. So I'd say definitely hire an attorney to do it. That would be my recommendation as it relates to H-1B visa cases. Let's see. How do you prove work experience if the company I worked for 4 years has gone out of business? I don't know whether this is related to an H-1B application or maybe a green card case or what have you, but quick answer to that, you might have the original employment offer letter from that company, or you might have pay stubs from that company or other types of documentation. All of that, in addition to a sworn affidavit by you, should work. If an H-1B applicant has a USA bachelor's degree, does that hold any advantage? No, it does not. What sort of sources fall under the S of STEM? Do MS program in any field or part of it? No, it needs to be actually a science related field. And there are many, many science related fields. If you're actually in a field where you think it might be related to science, the best way to figure out whether it falls under the S of that STEM is either to talk to an immigration attorney or talk to your international student office, and they should be able to tell you that. All right, looks like we've already hit 1 o'clock and we're out of time. If I was not able to address your question in this webinar, my email address is on the screen. Please feel free to email me or give me a call, and just state, if you call me, just state that you are part of the webinar, and I'm happy to speak with you and help you in any way we can. Apologize for some of the technical difficulties in the beginning and the fact that Amy could not be here to be a part of this conversation. Hopefully you found this webinar helpful. We'll have one a month on different topics for the rest of the year, and those will be posted on our website at www.bashyamspiro.com. We wish all of you the best of luck if you're going to file a new H-1B or going to be the employee or the beneficiary as a part of a new H-1B application on April 1st. If you need any assistance, do feel free to call us, and we hope everyone has a wonderful afternoon. Thank you for attending our webinar.